Good afternoon, lawyers. Welcome to the Appellate Division First Department. I am told that we have almost 4.5 hours of oral arguments. I will tell you what I always tell the lawyers. Please ask for the time that you need, not the time that you want. We have read your briefs. We have read the record. We are very familiar with your cases and your arguments, maybe more familiar than you're comfortable with. So I will begin the call of the calendar. People versus Gascioni.
Appellant requests 5 and 2, Your Honor.
5 and 2, and the people?
Right here, Your Honor.
5? Okay, thank you. 138, 140th Street West. 5 and 2 for appellant West 32nd, and respondent?
Respondent, 5 minutes.
Okay. We have M. Daisy is submitted. MC Sandra Vichet, MC is submitted. Belay versus Manhattan 140, appellant Belay.
Request 5 and 2. Respondent, Your Honor. 5 will be 5.
Thank you. Herman versus Judd Law Contracting.
Appellant, Your Honor, request 7 and 3.
Okay, well, you have a lot to say about the controller, so okay, I'll give you 7 and 2. Respondent Herman?
7 minutes, Your Honor.
Okay. Cosolino versus New York State Division of Housing, and we have a respondent intervener, Trump Park, that's the appellant.
Good afternoon, Your Honor. For the appellant, I would like 7 and 2.
For respondent Azolino, I would request 5.
Okay.
I don't think he is here.
Okay. Well, they're not asking for the case back then. I'll mark them submitted. People versus Sidbury is submitted. People of New York versus Sotheby's. Sotheby's?
Your Honor, appellant Sotheby's requests 7 and 2.
Okay. Okay, then we have Jeremiah's versus Tom Capital.
Appellant's request, Your Honor, 10 and 2. Respondents and cross appellants also request 10.
Okay. I'll just stop you when you start repeating yourselves, but I'll give you the time, 10 and 2 each. People versus Watson.
Good afternoon, Your Honor. Mr. Watson requests 8 and 2.
Respondent requests 6 minutes, Your Honor.
Yeah, I don't think we need that much time on 11. How about, I'll give you 6 and 1. And I'll give the people 6. If you can focus on the legal argument rather than some of the horrendous fact situation here, it will be appreciated. People versus Lewis, appellant Lewis.
Appellant requests 5 and 1.
5 and 1.
People request 5 minutes, Your Honor.
5 and 1 and 5. Nimkov is submitted. Krause versus Menkes is submitted. Uber Technologies is submitted. And then we have Godwell versus Sieber. Appellant Sieber.
Yes, 5 and 1, Your Honor.
Okay.
Requests 1, Your Honor. 5, Your Honor.
Okay, I'll give you 4 and 1 and 4 and 1 because you technically have an appeal. So if we need more as the last case, we'll take more. So let's get the first case on the calendar, People versus Gascioni.
Good afternoon, Your Honors. My name is Mark Zeno, and I represent Appellant Paul Gaccione. May it please the Court. Mr. Gaccione was convicted for his alleged role in a 1992 murder of Angelo Sangiulo. He was not charged until 18 years after the offense. The only evidence against him was the testimony of two cooperating witnesses who did not claim he was involved in the offense until many years after the offense itself. One of the cooperators, John Lito, was facing life in prison and received a time-served sentence after admitting that he was the actual shooter in this offense. The other cooperator, John Mamone, was also facing a life sentence for RICO and drug trafficking charges in federal court. And by claiming that Mr. Gaccione had admitted his role in this killing to him, he also essentially got off scot-free. While Mr. Gaccione challenges the weight of the evidence, here, what I'd like to focus on today is the Molyneux claim. It was Molyneux error to allow the people, with live testimony from one of the cooperators and the prosecutor reading a guilty plea allocution into the record, to show and prove.
I mean, the people argue on the Molyneux claim that that the prior conviction for tampering was introduced mostly to show motive. So what do you say to that?
Well, it was far more probative of propensity than motive. And I say that for two reasons. It was not very probative of motive because it had nothing to do with this offense. It occurred 2 years earlier. The people were not connected. Mr. Gaccione's co-defendant was not his co-defendant in this offense. The sole allegation of motive was that in each offense, Mr. Gaccione wanted to improve his standing with organized crime or within organized crime.
So he wanted to be made a member of the family. Why isn't that a sufficient motive and necessary to show why he was doing what he was?
Well, that would be a sufficient motive essentially for any crime. If the motive is the same for one crime, it would make the motive for another crime admissible. If somebody commits a robbery because they need the money, then it would make any other
But it
robbery.
wouldn't be in every instance. I mean, we do have a balancing that Molyneux requires, right?
Of course, and that's the second part of the test. So yes, if there are similar motives for two crimes, it's always going to meet that motive requirement, as it did here. Yes, they were both, according to the people's theory, admissible to show that he wanted to improve his standing. So they had overlapping motives. But yes.
Sorry, counsel. But wasn't it also an association between the defendant and Mr. Mamone? Because both were involved in the 1990 New Jersey Criminal Act, and their association together in the family, and ultimately it was your client who leaked to him the events of the 1992 murder. Oh, I'm sorry, do you hear me?
I could hear you.
I apologize.
No problem. I heard you, Your Honor.
So my point is, it's not just motive in a vacuum, it's the issue of the connection between Mr. Mamone and your client, both in 1990 and after the 92 murder, where your client, I'm waxing colloquial and meaning no disrespect, was bragging rights with respect to being associated with the murder in question.
Well, Your Honor, they were best friends, Mr. Mamone and Mr. Gaccione. There was the people didn't need to prove association, and there was abundant testimony about their association. The prejudice here, and this gets back to Judge Acosta's point about, well, what's the second part of the balancing test? The prejudice here is that Mr. Mamone was allowed to tell this story about the prior crime, how they intimidated this witness for whom they were attempting to collect a debt. He was cross-examined about it, and then the prosecutor himself read the plea allocution, Mr. Gaccione's own words, where he admitted that story was true. So they essentially corroborated Mamone's account and proved him to be a truthful person, when the whole question...
What about the harmless argument that even if it was error, there's two people who admitted that that he was one who drove the van.
This was not harmless. These were the two most incredible, biased witnesses that you could possibly produce. One of them alone would not have met the corroboration requirements. They each corroborated each other. It would not have even been statutorily permissible for a conviction if it were only a single one of these witnesses' testimony. It was surely not harmless. They had every motive to fabricate these claims. It was 15 years before they even made them after the offense, and credibility was everything. And this double Molyneux testimony, the account by the cooperator, then the prosecutor reading the plea minutes, made the witness much more credible than he should have been.
Okay, thank you, Mrs. Zeno.
Good afternoon. ADA Nicole Nichols for the Office of Darcel D. Clark. May it please the court. The court exercised sound discretion in admitting the Molyneux evidence. It was probative in this case. As the court recognized, the issue in this case was defendant's association with organized crime, as well as his relationship with Mamone. This prior conviction went directly to those two issues. Here, that prior conviction showed that defendant engaged in conduct in furtherance of his relationship or association with the Genovese family. It also showed...
It sounds like propensity, right? That's why I heard Mr. Zeno arguing. What do you say to that?
Your Honor, there's no propensity. Here, the defendant was charged in this offense with second-degree murder. That other case involved an allegation that he told an assistant not to make a phone call to the police during an attempt to collect funds. That is not showing a propensity for murder, and we would even urge it barely showed a propensity for violence, since the defendant's conduct in that prior offense was to tell the assistant, don't make the call. Really, it went to those key issues, and to the extent that it corroborated Mamone's testimony that he had such a close relationship with defendant, such that defendant would have told him about this murder, that is appropriate, Your Honor, given that here, the critical issue in this case, as acknowledged by counsel, was the credibility of Mamone and Lito, and that was assailed at trial. That was definitely the defense at trial. Therefore, if Mamone was merely allowed to say, we were friends, we were good friends, he certainly didn't admit that, defendant didn't admit that at trial, the prosecution had the right to prove that and to show that their witness was testifying truthfully on that issue. And they did that by showing that he said, we were collecting money for the Genovese family during this period. Here's evidence showing that they were doing that. They were convicted together for doing that very offense. And counsel, just briefly, the jury reasonably credited Lito and Mamone's testimony, that so long as those two testimony are credited together with the other evidence, there was definitely more than sufficient evidence to establish defendant's guilt.
I mean, you don't dispute that they both had quite an incentive to falsely inculpate the defendant here, right?
Oh, we do, Your Honor. While the issue of whether they had a criminal background or was associated with organized crime, that issue was fully presented to the jury. They were aware of that, and they credited the testimony. And there was no reason really to inculpate defendant. The reason that Lito got his benefit was for the assistance he provided to the federal prosecutors, not the state.
Mostly on Prisco, right?
Exactly. He said it. The day he was arrested, the federal prosecutors started asking him, what have you done with Prisco, who by that point had risen to captain of the Genovese's family. They asked for information about Palumbo and other high-ranking members of other organized family. The federal government wasn't interested in defendant, a non-made member of the organization, which is also evident by the fact that the federal government didn't prosecute defendant. They prosecuted Prisco, they prosecuted Palumbo and other members. but they weren't interested in defendant. So that showed that there was no incentive for Lito and Mamone to implicate defendant in this murder. And further of that,
Counsel, do you want to address the issue of excessive sentence for a minute?
Your Honor, the sentence here was appropriate. The fact that defendant is of an age at this time is purely the result of the fact that the defendant evaded the consequences of his actions for almost 20 years. This murder occurred in 1992, but defendant, unfortunately, because he and his fellow associates managed to get rid of the evidence and did not speak until they were implicated in other matters later on, that the evidence came to light, that's the only reason we were able to prosecute him later. So the fact that defendant got almost 20 years, where as the trial court recognized, he was able to be with his family and to live at large, does not now mean that his appropriate sentence should be reduced merely because of age.
Thank you, Ms.
Therefore, we would ask that the conviction be affirmed.
Thank you. You got 2 minutes, Mr. Zeno.
Thank you, Judge. I heard a lot of talk about what the feds wanted and who the feds wanted and why they wanted to, and what information they wanted from the two cooperators. None of that was in the record. There's no proof about who the feds' priorities were. The only evidence about...
But they didn't indict defendant, right? And they got Lito's cooperation, and they got the Lito's offering of information on Briscoe seems to be the underlying reason for the reduced sentence, correct?
For the reduced sentence, I think there were a lot of benefits that the cooperators offered to get a reduced sentence. And I don't believe there was any evidence before the jury when they made their decision to convict Mr. Gaccione about what the feds' priorities were in terms of why they wanted cooperation and who they wanted cooperation against. I want to address propensity. There's no requirement that to show propensity that it be the exact same crime. Intimidating a witness, here what happened was the cooperator was beating up someone to collect a debt, and Mr. Gaccione was alleged to have said to a secretary, "Don't pick up that phone and call the police." There's violence going on. Mr. Gaccione is participating. That shows a propensity to be involved in violence on behalf of organized crime, the exact same type of offense that he was convicted of here. And lastly, on the question of sentence, I did not hear anything that explained why a 15-year-to-life sentence for my now 74-year-old client would not be sufficient punishment. Prisco got off with time served for, Lito got off with time served for admitting he committed this offense. He got away with this murder, and he was the actual murderer here. My client was only alleged to have been the driver. He got away with time served. Mamone, for accusing my client, claiming and testifying that he committed this crime, I think got a 6-year sentence when he was facing
He's 74 now, right?
He's 74 now. He's not eligible.
What would a 15 years to life reduction mean in this case?
Well, he's currently eligible for parole in 2032. 15 years would lower that by 5 years to 2027.
Thank you, Mr.
And then it would be up to the parole board whether to release him. It would not be an automatic release.
Okay.
Thank you.
Thank you both. Okay. 138, 140.
Good afternoon, Your Honors. Evan Weintraub, Wachtell Misri, on behalf of appellants 138 West 32nd Street Associates and Joseph Simon and David Simon. May it please the court. This is an appeal from a lower court decision which granted partial summary judgment with respect to buyers of a real estate contract, even though the lower court found that the buyers failed to tender the down payment in accordance with the agreement. It concluded that there was other consideration that was given in the form of a loan pursuant to an oral agreement between the parties. Your Honors, to begin with, parole evidence with respect to any additional consideration is specifically barred by the terms of the real estate contract. The contract contained a merger clause. The contract contained a provision that no oral modifications were permitted. And the case law specifically provides that in the case of real estate contracts, that in the face of those two provisions, that no parole evidence should be considered. Now, what the court failed to do is even consider what the alleged purported documents that supported this loan were all about. They were not, in fact, additional consideration. The contract is very clear. The contract provided that it was a $3.6 million purchase price, $400,000 of which was the down payment. There is no mention in the real estate contract of any purported loan, of any purported additional consideration. And when you look at the three documents in question, they don't even mention the contract.
Well, putting aside this issue, isn't the consideration that I'm going to purchase the property at the agreed upon price? And your argument seems to be contingent to some degree on the deposit being due and owing. But isn't there an alternative interpretation, which the deposit was not due, that the breach occurred before the deposit ever became due because both of the brothers didn't sign it?
Your Honor, respectfully, the deposit of $400,000 was due upon the signing and execution of the agreement.
Right, and isn't it undisputed that there was a signature line for both brothers, and both brothers never signed the contract at the time they repudiated performance under the contract?
That's correct, Your Honor. And
Wasn't there an argument, and a fairly good one, that the deposit was never due under the agreement? It was breached before the deposit ever became due.
Your Honors, what the evidence actually showed here was that the reason the deposit wasn't tendered and the contract was void is because both parties knew and understood that they continued to negotiate here. That is the only explanation for why 1 month after the contract was signed by one of the brothers, the buyer is submitting a written letter of intent with entirely new terms. Now, instead of a purchase of $3.6 million, it's a lease with an option to buy the property. The only explanation here is, Your Honor, is that sophisticated parties who are negotiating a multi-million-dollar deal for real estate, if you truly believed you had an enforceable agreement back in January, there's no reason to continue negotiating and then a month later submit a new letter of intent unless you didn't believe that you had an enforceable agreement. And that's what the evidence showed here.
What's unenforceable about that agreement, though?
I'm sorry, I didn't hear.
What is unenforceable about that agreement? Why is that agreement unenforceable?
The agreement is unenforceable because the buyer failed to tender the deposit in accordance with the terms of the agreement. And that is a material breach. And again here, the judge below acknowledged that they failed to tender the deposit in accordance with the contract, and that the only reason that he granted partial summary judgment was because he considered this additional consideration, which, as I explained, never should have been considered because it was barred by the terms of the contract, and B, the documents themselves are unenforceable.
Was there time of the essence in that agreement?
There was no time of the essence.
So
but
case law supports the notion that a delay in performance, which happened here, in tendering it a little later, is not necessarily a basis for rescission.
But the case law does not support that even in the face of the fact that there was no time of the essence, the failure to tender the down payment in accordance with the terms of the agreement, Your Honor, is a material breach warranting rescission of the agreement.
Thank you.
Thank you.
May it please the court, Kevin Nash for the respondent. I believe that the lower court correctly decided this case on multiple bases. In terms of the consideration, I think the trial court pointed to the fact there was multiple forms of consideration. This issue over the deposit, as we argued, the deposit was due upon full execution. That means both brothers had to sign. And if you want to look at the four corners of the contract, it clearly says delivery in full execution. There were signature lines for both, so the deposit wasn't even due when they reneged on the transaction. In terms of the notion that there's no consideration, I think it was correct that the contract on itself has mutual promises. Mutual promises, seller sells, buyer buys. I think on its face, that's consideration in and of itself. The delayed deposit, was, as Your Honor said, is not time of the essence, and there was no default issued at all. What happened was when the deposit was tendered, they deemed the contract void. And they never recognized the contract, and they prematurely repudiated. So I think that the decision below is very strong on these points. I would just note that the main argument before the court was whether or not there was authority on one of the brothers to sign. The court found, based upon tax filings, that there was. And the court was, he focused on the alternate consideration, but he never said the contract was unenforceable because of the delayed deposit.
Counsel, could you explain, if you would, the anomaly, the apparent anomaly that's highlighted by your adversary between the fact that Mr. Moynihan signed the purchase agreement, but also signed the letter of intent to lease?
I don't know if it's an anomaly. After the contract was signed, this loan transaction that one brother got, the other brother looked to get a similar transaction. It didn't undermine the fact that they were already under contract, and it didn't undermine the fact that they were discussing post-execution of the contract an alternate payment mechanism for tax purposes. So there's nothing anomalous about that. If they would have came to agreement, they might have done 2 loans for each of them, but there was nothing anomalous about it. They continued to discuss how they're going to pay off the purchase price after the contract was signed. That could be discussed all the way at a closing table and the weeks leading up to the closing table. So I don't think that undercuts the contract in any way. It's just that the parties did have discussions as to alternate payment. And one brother didn't reach agreement on that, and I think that's why they reneged on it. But when they reneged, it was an enforceable contract.
Thank you, counsel.
Your Honors, very briefly, the letter of intent that was sent 1 month later was not just talking about tax effects or payment terms. What it did was changed the entire agreement from a purchase to a lease with an option to buy. Moreover, Your Honors, the 3 documents in question that the lower court found were the additional consideration bear no relationship to the contract at all. One is a letter, not by the buyer, but by the buyer's principal, purporting to loan money to one of the brothers. The second document is an unsigned promissory note, which is unenforceable. And the third is a guarantee by, again, not the buyer, but the buyer's principal, to pay one of the brothers a monthly sum if the brother became a member of the buyer LLC, which never occurred. All of these documents show that There was never an agreement, and the parties knew it, and that's why they continued to negotiate beyond the contract. Thank you, Your Honor.
Thank you both. Belay versus Manhattan 140.
Good afternoon, if it pleases the court. Robert Grimble from Grimble and LaJudas. I would hope this would be a fairly simple appeal. We have a situation with the building, an old building, no certificate of occupancy, no proof actually of how it was used 100 years ago. We do have proof that it had 8 or more units for a long period of time.
It's a simple appeal on a motion to dismiss posture, right?
Yes, and it was actually a 3211 motion,
Right.
which the judge apparently changed to a 3212 motion.
Right. Was there any notice to the parties?
No, and that was actually raised
Usually
in
when we-
argument. And that
Do
was
you
raised
think that that's required if we're going to search the record?
That is how I read, I think it's 3211C, that there must be, and not only that, there's a triable issue of fact. I mean, the issue is, are my 2 clients rent-stabilized tenants? We have proof, including an affidavit from the principal of the defendant respondent that says they're rent-stabilized tenants. So for the court to say there's no triable issue of fact.
Is it disputed that there are 8 units in this?
Yes, the HPD registration shows 6 Class A units and 2 Class B SRO units.
So that sounds like 8 units. 6 and 2,
That's more than
maybe
6.
my math is,
That's, yeah.
so it's 8, right? And
Right.
is there any dispute that the building or the structure was built prior to 1974?
No, as a matter of fact, there's an affidavit from the defendant's principal to the effect that it is so old that there's no certificate of occupancy, which I make it before 1929. If I remember I wasn't there then, but that's my recollection of the year.
But there were I-cards in the record that verified the conversion historically to residences, Class A's and B's, correct?
It appeared from the I-card, and unfortunately the record's not as good as it might be because of the conversion, but there had been used as an SRO during World War II with 6 or more units. So the use of it as a 6 or more unit building was quite long-standing. And it suffered a casualty. The fire stairs collapsed. My clients got thrown out on like Thanksgiving, and the judge ordered various things to happen. When we brought a contempt because my clients weren't back in possession, the work wasn't done, there's a cross motion to dismiss based upon documentary proof, and the judge dismissed the case.
Well, the proof they rely on is simply a letter saying that we have some kind of information from HPD that somehow changes the fact that this is would otherwise be a legitimate multiple dwelling, correct?
Well, actually, yeah, it was HPD or DOB, I forget, that the landlord had filed something to make it a single-unit building. But this is all what the landlord, the defendant, filed.
But that DOB letter does, I don't think, refuse plaintiff's claims to rent stabilization status.
No, I
And
don't.
we are at 3211 stage, which is why I mentioned it in the first place.
Yes, that is exactly my position on it. If you got 6 or more units, they're rent stabilized, and that's basically it. You know, it's pretty straightforward. I will
was
yield the
just gonna ask
remainder
you
of my
about the
time unless there are
injunction.
questions.
I was going to
Yeah.
ask you about the injunctive part of the motion, your position on the injunction.
Judge, on the injunctive portion, we had moved and obtained a court order, which I know defendant is saying was on default. Actually, if you read the order, their papers were submitted. They didn't orally argue.
Let me ask you, in terms of the substance of it, part of what you're asking for seems the ultimate relief in the case, which is that it be restored, but isn't that the ultimate relief that you're actually seeking in the case?
Well, actually, no. There's various ultimate relief, including declaratory judgment that they're rent stabilized and so on. The preliminary injunction, we required them to be put back into possession and get their
But isn't that the
property
ultimate
back.
relief that you're seeking, to be put back into possession?
Well, yeah, and we would, I mean, and there would be further. We'd also have their rent regulatory status declared.
So you just don't want to be restored to possession, which would have been the status quo. You want to be restored to possession with a declaration that you rent stabilized.
Right, and I know that the lower court said, well, this is without prejudice to seeking damages. The problem is that if the court dismisses the claim that they're rent stabilized, there's no damages.
Right.
And so if there are no further questions?
Good? We good? Thank you.
May it please the court, good afternoon, Your Honors. James Demetrio on behalf of the respondent, Manhattan 140. Before I get in, I would like, if I don't mind, just to address some of the things that counsel said and in the discussion with the court. There never was an official multiple dwelling status to this building. What happened was some
Counsel,
prior owner.
under the relevant standard, which is the amount of units and how they're actually being used, isn't that the issue that the court needs to look at in terms of determining whether these apartments are rent stabilized? How many apartments were being used and how they were being used?
It may, Your Honor, but.
Isn't that the law?
I
Under
submit.
the rent stabilization law?
I respectfully submit, Your Honor, that the rent stabilization issue is not the issue in this case. The issue is.
Well, how could it not be the issue if that claim was dismissed? Part of what they're seeking in this case is the declaration that they are rent stabilized, and that claim was dismissed.
That's correct.
Excluding them from pursuing that claim, so how could that not be an issue?
Because the lower court decided that, and if I may, let me draw a different analogy. Discussing the rent stabilization issue is putting the cart before the horse. There is no cart in this issue. The Department of Buildings, some old landlord had a one-family house, decided he wanted to make more money, put up a few walls, put in a few, if you look at the record.
Counsel,
I'm sorry,
isn't there a big factual dispute about why it is no longer the issue, the vacate order was issued, that it was actually, there's an allegation that the landlord created that situation by blocking a means of egress?
I'm sorry, Your Honor, no. The vacate order was issued because the building department came down and said, this has always been a one-family dwelling. We issued a letter of no objection because some guy decided to bring in some roommates in at one point.
Well, now we're going to revoke. Now that 8 people are using it, why can't it be legalized to be a multiple family dwelling? What's preventing that from occurring if that's a use that's actually been in place for a very, very, very long time?
And that is the basis of my argument, Your Honor. The courts are without the authority and without the power to direct Department of Buildings to issue a certificate that says this is a multiple dwelling.
So we without authority to interpret the rent stabilization law?
We never get.
That consider a unit or a house or a building of 8 units built prior to 1974 as a de facto rent stabilization?
I'll answer your question this way, Your Honor. Absolutely. If it's a one-family dwelling and we can't get Department of Buildings to turn around and change it, then they could be rent-stabilized tenants by judicial.
But why can't you get DOB to do it? You introduced the DOB letter of September of 2019, and that letter doesn't even refute the tenant's claims.
That letter does not address rent stabilization. That letter just says we have a one-family dwelling.
It doesn't refute. See, the issue here is of burden. We're not 3211 motion. You have to resolve all of the issues in your favor as a matter of law.
Yes.
Okay? Or the evidence that is introduced has to refute.
Your Honor, I just want to make one comment about the existence of the building and how it was and why Department of Buildings issued this letter. If you look at the record on appeal, there's a picture at page 33 of the record.
Counsel, if you look at the I-cards indicate, as my colleague Judge Hillman referred to earlier, the I-cards indicate that since at least 1944, 6 occupants resided in the building, and 6 units have been in place throughout most of the building's history. So the issue here, which probably cannot be resolved at the motion to dismiss stage is whether or not the building can be restored to its lawful use. Wouldn't you agree?
Whether it can be restored to,
Right
I
now-
go one step further, Your Honor, I'm sorry. I believe the issue is, can we require the Department of Buildings to change the one family into, I'm sorry if I may just have another minute.
You can go ahead.
The list of violations attached on page 24 of the record says, run gas lines, discontinue rooming use, and then file plans if feasible.
Sir, you raise a very good point, but this is how I understand those violations here. And again, we're still dealing with the pleading stage. The focus here is whether these tenants have accrued certain rights because of their use of the apartments over a period of time. Continuous and exclusive use, which is not really disputed here. They were forced to leave because of a vacate order. We understand that. The critical violation, respectfully, is not an illegal basement apartment where it's missing windows or something like that.
That is correct.
Just breathe. It's a secondary means of egress, which...
It's what, I'm sorry?
A secondary means of egress,
Yes,
another
okay.
stairwell, which I can't really speak clearly as to what caused it, whether it was intentionally blocked, we don't know.
Oh, no.
But the bottom line
That's
is
what
that they
trials are for.
they were residing over 2 Class A apartments, the tenants in question. They weren't in a basement. And the question is, can this easily be resolved? Because we have many situations where our case law has addressed de facto conversion to multiple dwelling, only to file plans and clean it up so that we can now make it legal and have a certificate of occupancy issued, laying it all out, 2 ways on floor 3, 2 ways on floor 2, et cetera. That's what's going on here. So at this stage, it just makes sense to just play it out and then to preserve everybody's rights. Maybe you shouldn't be forced to do certain things you're not supposed to do based on a so-called mandatory injunction of the November 2020 order. And maybe they may be entitled to a preliminary injunction just to preserve the status quo, that you shouldn't block the tenants from being restored if everything gets sorted out. I mean, that's really what's going on here.
I respectfully submit, Your Honor, that I understand the argument of a de facto circumstance, but that de facto circumstance still doesn't change that everything has to go through DOB and get their approval. And there's nothing in all of my research, there's nothing that allows the courts to turn around and say, DOB must change the status of this building from this to this. And if you want to follow it up with a single-family dwelling, great, we'll make a couple repairs. You know, I'm sorry, I don't mean to belittle it. I'm not intending to, please forgive me.
I understand.
We make a couple of repairs, we have a valid one-family dwelling, and one of the appellants can come in and stay in a single-family dwelling.
But it's not as simple as that.
As a rent
But
stabilized.
it's not as simple as that, right? How long have they been there living in the units that are there?
Long before my client.
That's what I thought.
That's also why I referred to the picture at page 33, because the kitchen unit is a modular unit of a sink and stove combination that's electric, plugged into a wall, when the violation came in and said, run gas lines if feasible. All of this ties back to Department of Buildings. That's what it's all about.
Thank you, counsel.
Thank you.
Your Honors, if there are no questions, I'd waive my reply.
I think we're good. Thank you.
Thank you, Your Honor.
Smart. Herman? To
Good afternoon, Your Honors. Matthew Calley from Troutman, Pepper, Hamilton, Sanders on behalf of the appellant. May it please the court. The Supreme Court's decision resulted in an award of prevailing wages for every single minute that the plaintiff spent performing work on defendant's construction projects over a more than 10-year period. That's just factually and legally incorrect. The decision is unsupported by the record. It's contrary to the 2001 Comptroller's Memorandum. It's contrary to the express terms of the city's contracts that they have with the defendant, and it violates New York law. The plaintiffs were hired to perform pedestrian crossing guard works, and according to the contract with the city, that is not a prevailing wage earning job because there is no...
Who gets to determine whether it is a prevailing wage job?
The comptroller does.
Right, not the city, but the controller, who separately acts as the commissioner of labor, right?
Correct, and
And how does he interpret that position?
So the pedestrian crossing guard position has actually not been interpreted by the comptroller because it's not related to the construction work. There's no classification for that. So that pedestrian crossing guard work occurring outside the construction zone is not prevailing wage work, and for that reason alone, the Supreme Court's decision is against New York law because it awarded prevailing wages for
But that's not what the record, I'm sorry to interrupt, excuse me. But that's not what the record says. Your own witness, David Suma, if I got his name accurately, recognized that these flaggers were working in close proximity, his words, to the construction site, and that their function was a safety function to protect the public from construction dangers. Much of what we see in the city of New York, and I know I don't mean to sound to whores the record, but we typically see flaggers right near a backhoe in the middle of a roadway telling people, don't come close as the backhoe is moving over to do what it's supposed to do, which would squarely and factually put the flagger or laborer in the heart of the construction project, and not merely being a crossing guard to simply say, okay, we're moving traffic because we don't want to just block the roadway.
So
Wouldn't you agree to that? That was your own witness at the hearing.
I'm sorry, Your Honor?
I'm sorry, that was your own witness at the hearing, wasn't it?
Well, what you're describing is work that was performed by a flag person performing laborer's work. So the pedestrian crossing work is different than that. And it's actually different than the work described in the 1998 letter and the 2001 clarifying
What you're saying
memorandum.
doesn't make sense. How is what he describes as a function operating as a pedestrian crossing guard? It's exactly the opposite of that. So where are you getting in the record the basis for your argument that they were acting as pedestrian crossing guards as opposed to being involved in the construction site?
So I believe it's on the record, page 1227 to 1230. In the contracts with the city, it describes a crossing guard position as well as a uniform.
But that's a contract with whoever drafted the contract, whether the city or the other side, determining whether the particular functions that are being performed convert that individual from a flagger who gets prevailing wage, right? So what was mentioning by Judge Shulman is the May 98 definition or interpretation of flagger, and then the May 2001 clarification. Correct?
Correct, and the 1998 letter and the clarification letter specifically relate to the flagging work of vehicles. And what's important to note in this context is that the 2001 memorandum...
It refers to flaggers primarily assigned to alleviate congestion by directing the flow of the street traffic away from the vicinity of the construction site.
Correct, and if that work is primarily done outside of the construction zone, then that is not prevailing wage work according to the 2001 memo. And the key distinction that we tried to show in our papers here is that...
Counsel, Mr. Suma did say that the flaggers worked on, adjacent to, or in close proximity to the construction zone. I think we're familiar with what a crossing guard does. The crossing guard generally stays by the traffic light. This is someone who engages in a very different function. And don't we need to look at the nature of the work that's actually done here?
Yes, we do. And the key difference between the language that you just used, the on adjacent to or in close proximity to, that's not the controlling standard of what determines whether a flagger is entitled to prevailing wages. The 2001 memorandum, which was issued for clarifying purposes, expressly removes that language and differentiates.
Did it refute the language? Did it rescind the language? Did it rebut the language?
Well, the purpose of the memo was a clarifying memo issued to the same recipient in the Department of Construction, the mayor's office.
And what was the clarification?
The clarification, frankly, is to remove.
So the flagger is not primarily on the construction site, but is primarily assigned to alleviate congestion by directing the flow of the street traffic away from the vicinity of the construction site, and I was quoting, then Labor Law 220 does not apply. That's your argument.
Correct. That initially, and it's also telling that the 1998 letter, if applied as written, would reward prevailing wages to individuals both working on and off the construction site.
Is construction site defined?
In the contracts, it is defined.
No, I'm not interested in the contract. I'm interested in how the controller defines it.
I'm not sure whether the comptroller defines specifically what the construction site is, but on the construction sites at issue in this case, there were barriers that separated the construction zone from everything else. These plaintiffs were performing their flagging work outside of the barriers. It's undisputed they're outside of the barriers.
But usually flaggers are outside the construction site because usually they have to divert traffic or congestion of traffic around the construction site, right? Assuming that there's a wall or there's some sort of a fence. The flaggers have to be away to move the traffic on the perimeter of the construction site, right?
Correct, and that's why the city interpreted it the same way we did. There's no comptroller definition of a flag person that works outside the construction site entitled to prevailing wages, and that's the key differentiating factor in this case. Now, to the extent that any additional work was performed by the plaintiffs, such as any sweeping, moving of cones or barrels, et cetera, while it's our position that it's disputed that that work was actually performed, they very well may have performed that work, but there are issues of fact, because if they did perform such work, they're only entitled to prevailing wages for the time spent performing that type of work, not for the entirety of their job.
Okay. Thank you, counsel.
Thank you.
So what's unreasonable or irrational about the controller's interpretation?
Should I introduce myself, Your Honor, first? Or
Sure.
straight to it? Okay. May it please the court, my name is...
No, it's 6 minutes, so
Oh, sorry.
I'm trying to cut to the chase.
Taylor Graham for the plaintiff respondents. I'm sorry, can you repeat your question then, Your Honor?
Yeah, what's irrational or unreasonable about the way that the controller is interpreting a flagger's responsibility?
Absolutely nothing, Your Honor, and that has been the long-standing guidance from the comptroller since at least 2001. The distinction is between traffic control flaggers who are at a remove from the construction site primarily to divert traffic from the construction zone, and safety flaggers who are on or about the site with the intent of controlling the safety to the public and to the construction workers.
And that's exactly what the defendant's witness said.
Exactly, Your
And
Honor.
that the plaintiffs, your plaintiffs here, are safety flaggers and not traffic flaggers.
Correct. There's no evidence in the record that they were doing any sort of traffic control work. And in fact, throughout the case, defendant took the position that they were only supposed to be flagging pedestrians, so they could not have been, a block away directing traffic from coming into the site. And as Your Honor recognized, it was David Suma, page 428 of the record, was asked directly, but you would agree that the flaggers worked on, adjacent, or in close proximity to the construction work, and he answered yes. And he continued, and they protect the public to inherent dangers on or about that construction site, and he answered yes. So they do fall squarely within that safety flagger category.
And would you agree that the testimony of your clients, if I got it from the record accurately, was that they were principally safety flaggers, but then had additional duties sweeping up or doing some other, what they consider other flagger-type duties that somehow would affect your client's ability to get the prevailing wage for the bulk of their time.
Absolutely, Your Honor. Yes. So, and that goes to defendant's de minimis argument. So these other non-flagging duties, the sweeping, the carrying tools, those should not be in dispute, are labor duties. But the de minimis argument doesn't touch on the flagging duties at all, which was their primary duty. And that duty was to ensure the safety of the construction site, the public, and the construction workers on that site.
And ultimately, if the matter is referred to a referee, then that would be sorted out.
Yes, and it was referred to a referee
Right.
in terms of damages.
Right.
Right, but after partial summary judgment have been granted, right?
Correct. Summary judgment has been granted as to liability in total. And as counsel said, it's for every minute that they spent on the projects throughout the time, because they were doing safety flagging work or labor work every minute that they were on those projects. And that's...
Yeah, and the testimony with respect to how much time each of the plaintiffs spends doing qualifying prevailing wages work, yeah, I mean, doesn't it, because I know that that's part of the de minimis argument being made, but shouldn't that be an issue for trier of fact?
So it's essentially a straw man argument, Your Honor. It purports to discuss the amount of time that prevailing wage work is done, but it ignores the amount of time doing safety flagging work, which is the prevailing wage work. So it focuses entirely, by admission, on the other types of duties. So based on the comptroller guidance, the safety flagging work is also prevailing wage labor work, as well as the other duties.
So if it's 80-20, say 80% doing flagging work and 20% doing all the non-prevailing wage duties, then that's something for the referee to consider in allocating damages.
Sure, Your Honor, but just to be clear, it would be 80% or more doing the primary duties, which are safety flagging.
Right, and you get
then,
prevailing wages for that.
Right, and you also get prevailing wages for the other labor types of tasks, which are the sweeping, the carrying tools, the assisting the other laborers.
Right.
So
You're saying that determination's already been made, though, that for 100% of the time,
right.
they get prevailing wage, and the only issue is the computation issue of how many hours worked and what's the prevailing wage.
Yes, and
Because either way, if it's flagging work or it's a sweeping, it's all prevailing wages.
exactly. And the defendants kept track of the hours that were worked on the project as they were required to. So calculating damages, as the Supreme Court acknowledged, can be done based on the records of the time they spent doing that work.
Okay.
And it's consistent with the U.S. Department of Labor's finding. There's also a DDC project on Chambers Street where they were doing exactly the same type of work. U.S. Department of Labor found that that work was misclassified, should have been paid as labor work, not pedestrian traffic guard work. And it's consistent with plaintiff's expert who used to work at the comptroller's office and was the director of classifications, and that expert testimony is unrefuted by the defendants.
Okay, thank you, counsel.
Thank you.
Just like to touch on a few things that were mentioned. First, the plaintiffs admittedly were not on or about the site. They were off the site, either adjacent to or close proximity, or off the site altogether. And the standard in the 1998 letter, which has the adjacent to or close proximity to language, is not applicable when the 2001 memorandum was written to clarify.
How could a flagger ever be inside the site? Because obviously part of what a flagger does is helps trucks get in and out, keeps pedestrians away. How could they do any of that work from inside the site? You would never do, if your definition of being inside the site, a flagger would never be doing flagger duties.
So an example would be if that there was a construction vehicle coming onto the site, and that person was flagging on the site, flagging them in to the site.
So they'd be hiding inside, and they'd only come out for when a truck was coming in, and that would be their only duty?
Well, not necessarily hiding, and not necessarily their only duty, but that would be in the 2001 memo, a laborer that has assigned a different task when there has to be flagging
You're
done.
defining it to mean inside the site, not adjacent to the site. That's how you're trying to.
Correct, and that's what the 2001 memo says. It says when a flagger is primarily assigned off the construction site, not all the time off, but primarily assigned off the construction site, and they perform flagging duty, that's not prevailing wage work. But if they're on the construction site, then it is prevailing wage work. and these plaintiffs were not on the construction site as required by the comptroller standard. And that goes into the deposition testimony from David Suma, whether they were adjacent to or in close proximity.
I thought it was more than that. I mean, you know, reading the May 2001 clarification, it talks about protecting the public, you know, on the construction site, but protecting the public from inherent dangers on or about the site, not just inside. You want to limit it to a particular location, but this doesn't do that. The clarification doesn't do that. It's safeguarding the work crew from the street traffic. They can't do that from inside, right? And directing the movement of construction equipment in, on, and off the site. You can't do that inside. I mean, you want us, I guess, to substitute our interpretation for the controller's interpretation of what the job site is, I think.
But part of the reason that the thing that has to be considered is when they're primarily assigned off the construction site, the initial class that the comptroller notes in that 2001 memo, and these plaintiffs were primarily assigned to work out to the construction site. They're located on sidewalks across the street. Maybe a few of them may have been near the entrance barrier, but this is an entire class of plaintiffs we're talking about. Not everyone was standing immediately at the entrance to a construction barrier. And for that reason, there are...
Well, it's a class of workers. I mean, okay, never mind.
There are questions of fact regarding whether they perform prevailing wage work and to what extent that they were entitled to prevailing wages.
Okay.
And if I may, just one last thing about the Department
I'll
of
give
Labor
you 30 seconds.
Okay, thank you, Your Honor.
Oh, you don't want the 30 seconds?
Oh, I'm sorry. I thought you said...
I thought you asked me.
No, I thought you said you already said this, so excuse me. The Department of Labor's investigation that counsel referred to, that was on a federally funded project. That included the application of the prevailing wage schedules under the Davis-Bacon Act, which is not applicable to this case. In that case, the Davis-Bacon Act has a much broader definition of what's a laborer and who is a laborer that provides work on a federally funded public works project. And additionally, the defendant did not have to pay any back payment, make any back payments to the plaintiffs in that matter. The city was the one that made the payments because their interpretation of the prevailing wage position of a flag person was that it was not a prevailing wage position.
Okay.
Thank you.
Gasolino.
Good afternoon, Your Honors. May it please the court, Magda Cruz for the intervener appellants.
Good to see you again, Ms. Cruz. At least since the last time we got reversed by the Court of Appeals. So.
Thank you. And let me just get to the heart of the issue. The Rent Stabilization Code defines family member for succession purposes with two requisite elements. That has been something that this court and the appellate department.
Does everyone agree, Ms. Cruz, that all of the elements have been satisfied except DHCR found one?
No. DHCR had to determine if the two requisite elements were proven by the applicant for succession rights by the preponderance of the competent evidence. Those two elements are emotional and
they found,
interdependence.
The DHCR found that plaintiff proved emotional relationship based on the affidavit,
yes,
the power of attorney,
yes,
the will,
yes,
all of that, right?
Yes.
Any of the photos that were introduced, although a smart aleck remark notwithstanding about the
yes,
photoshopping.
but that's not why we're here, Your Honor. We are here because one of the requisite elements was not proven.
Well, what do you say requisite? I mean, I understand. I mean, the DHCR said a dearth of evidence of financial interdependence.
That's right. That's right.
Is that a requirement?
Absolutely, that's a requirement. In the most esteemed appellate term, First Department cases, which I am sure that this court is aware of, This issue has come up on multiple occasions. My brief goes over at least 4 to 5 cases where this issue was in fact addressed, where the parties may have had emotional criteria, but did not have the sufficient financial interdependence and commitment. No financial intermingling was found in this RTCR.
You saying the First Department precedent has in effect trumped the requirements of Brashi and the rent stabilization law, that one factor alone is
No.
not dispositive.
Your Honor, it is not a factor. It is an essential element. If you look at the regulation, which is what the commissioner did, emotional and financial commitment and interdependence are the elements necessary to succeed under the non-traditional family member succession regulation. All those other factors, those 8 factors that follow the text of the regulation, those are the ones that one can have some or may not have others.
I'm curious.
Ms.
because
Cruz.
For so long, women in traditional relationships have had to prove the value of their status, of the economic value of their work, because they didn't have a job. They stayed home. They stayed home, with or without children. They stayed home. And I don't see much of a difference here. You have a relationship that's long-standing. You do have someone who's older than the other. You do have someone who has financial means, at least until the point where he had issues and was incarcerated, but he had financial means of significance. And his partner benefited from that. So where is the difference? When you have all of the emotional criteria, you have the family relationships, you have the will, you have the healthcare proxy, you have all of the above, you have proof of residence. Where do you see the difference between the traditional homemaker and this man?
I will tell you the difference, Your Honor. In your hypothetical of a heterosexual relationship, you have, and if there was no marriage certificate, say like it is more like the case of Zenker, which was before this court, as well as before the appellate term, you have a situation where there was some evidence of financial commingling. The point in this case is that there was no financial commingling. It is a requirement. That is our argument. It is based upon the law, as well as...
Why does, Ms. Cruz, why does the regulation say that a non-traditional family member must prove emotional and financial commitment and interdependence between such person and the tenant or permanent tenant, though no single factor shall be solely determinative?
Correct, but Your Honor, the factors that the regulation is referring to are the factors below that.
Yeah, the 8 factors.
Correct. That's
Right.
different. If I'm not arguing that all of those 8 factors are necessary, they are not. What is necessary is some indicia of financial interdependence and commitment. And here, I know my light came on.
No, go ahead. No, you go ahead. Marty, go ahead.
I'm sorry. Ms. Cruz, I understand your point perfectly, but I also understand that you're essentially asking us today to reverse this court's precedents that have determined the key ingredient that you pointed out, the key element of both financial and emotional interdependence must call the day. And I know from prior experience where, and I apologize because I don't have the case right here, where where the appellate term reversed a trial court on that issue, in the absence of financial interdependence, the absence on that record as a matter of evidence, and this court reversed the appellate term and said, based on what
If I
presiding
may,
justice raised, that when you have the totality of circumstances that reflect a family-like relationship, as is essentially undisputed except for the financial aspect.
right. If I,
That our court, basically said that's not a deal breaker. And therefore, even in the absence of that one factor, it should not defeat succession. That is the valid precedent that we have here. Among others is the RHM case, and there are others
yes,
similar that post-date that case.
yes.
So how do you ask us to say, Judge, justices, we want you to throw all that out because of the absence of that one factor when the totality suggests the interfamily relationship that should arguably support succession under Braschi?
Because I'm not asking you to do that. Because those cases, Your Honor, most respectfully, related to relationships in which the two individuals either did not have financial resources that really would trump the emotional factor or the emotional criteria. You had people that were indigent. They did not have the means to have joint accounts. They did not have joint brokerage accounts. They did not have, as in this case, Mr. Casolino had a very high-end lifestyle where you have evidence in the administrative record that he was a member of a hotel and travel rewards program. He had a Fidelity brokerage account. In the instance of our case, in the situation of a non-traditional family member, including Braschi, which was a relationship also among two people that had means, though Braschi had much in the way of financial interdependence. They had bank accounts, they had brokerage accounts, they had even safety deposit boxes. If you read that decision, you will see there's no comparison between Braschi and this case. So no, Your Honor, I am not asking you to overrule precedent.
Although
I'm actually asking you to adhere to the precedent of the First Department and this court on this issue.
Although Braschi was clear that this court, no DACR, should be the one defining for a couple their relationship, right? We do look at those factors, but we don't decide how they manage their finances.
No.
What emotional interdependence looks like or even means.
No, those factors are to prove the two essential elements. In this case, one of those elements is not present, and the DHCR commissioner got it right, and the Supreme Court should have adhered to a correct statement of law that was supported by the administrative record. And
Thank you,
I reserve
Ms.
some
Cruz.
time for my reply. Thank you.
Please the court, Robert Grimble of Grimble and LaJudas. Good afternoon again. I will try to be very brief. One, between the DHCR regulation and the Rent Stabilization Code and the Court of Appeals in Braschi, I suggest the Court of Appeals wins. The Court of Appeals lists factors including financial interdependence and emotional interdependence as one of the factors, no one of which controls. Second point, the DHCR decision is really not even based on a lack of economic interdependence because quite clearly Mr. Casolino and the decedent had an economic interdependence. You can have an economic interdependence without a joint bank account. And I think looking at this, if you've got people that are an emotional and economic unit, it doesn't matter whether they have a joint bank account or not. That can happen in a number of ways. You can have partner A working, partner B staying home, taking care of the two kids that are in college. Now, if the partner who's earning the money dies, are the kids not entitled to succession because they didn't, nobody shares a joint account with their 19-year-old kid? And again, comparing this to other types of relationships. How many marriages have a prenuptial agreement? In how many relationships do the partners set out in advance to keep their finances separate? Does that make it less of a family relationship? Now, just one more item. Looking at Braschi, Braschi really does, and I was very surprised looking back 30 years since I read this initially, but it doesn't talk about equal protection very much. It doesn't really talk about equal protection at all. It's an interpretation of the law. I suggest that there is an equal protection issue here because, for example, the decedent in this case couldn't really have a bank account. I mean, I'm not saying he's a really wonderful person, but he couldn't have a bank account. I have plenty of clients who are too poor to have bank accounts. I have clients without green cards. There are a lot of people who don't have joint accounts and may not have any account at all. They should not be treated any differently. The issue, as stated in Braschi, is looking at this as a whole. Does it look like a family? Is there a sufficient degree of self-sacrifice? Mr. Casalino took the decedent's children to visit his son, to visit him in jail repeatedly when the decedent was in jail. Now, it's not a good thing the decedent was in jail, but who but a family member would do this? I mean, really. If you have no further questions, or if you have no questions?
I think we're good. Thank you.
Your Honors, I think we should not forget the procedural posture of the case. Okay, this is in Article 78. You have a lengthy decision by the commissioner. He certainly was not acting arbitrarily or capricious in his analysis of all of the facts. He gave credit to the petitioner.
Did they take up, the DACR take a position on whether this was an error of law or not?
I understand that DHCR's position was that they wanted a remit in order to do some more
You don't want this
analysis of the
remitted, right?
facts. I don't think a remit is necessary. I argue that in my brief. But in the alternative, if the court deems that a remit is appropriate, at the very least, you must order a hearing so that we can test the veracity and the credibility of this kind of evidence. If you recall,
But wasn't that
What's missing? I don't understand what's missing. You even have an affidavit from the son who says that Mr. Cosolino was a groom at the son's wedding. As counsel said earlier, they went together to visit the decedent. The son says, he is part of our family. I don't get it.
yeah,
What else is needed besides the affidavits, the healthcare proxy, the last will and testament? I mean, you know that there was a 30-year relationship here. So what else is needed?
Our position is not that anything is missing. In fact, to the contrary, we also agree with Your Honor that everything is already contained in the record. But if you're going to remit in order to look at this evidence, I submit that the interveners ought to have the right to question the affiant, the son, to question Mr. Casalino. They have firsthand knowledge of the nature of this relationship, and the record also contains quite a number of inconsistent representations by the tenant, not the least of which, if they had such a close and loving relationship, I believe that there is a question about why wasn't he added to the lease years ago? Why would the tenant say that he wasn't living with him less than 2 years before his death on an application for government benefits? Why in 2003 the same, that these two were not in a committed relationship? Those are inconsistent statements in this record. If there is a remit, we should be able to question those. That is what I am submitting, although I do not believe My client does not believe that a remit is necessary. Here, the court should have deferred to the correct and well-founded and supported by the administrative record, the decision by the DHCR's commissioner. Thank you.
Thank you, Ms. Cruz. Thank you. People versus Sotheby's.
Good afternoon, Your Honors, and may it please the Court. Darren Laverne of Kramer Levin for the appellant Sotheby's. Your Honors, in this matter, the Attorney General is attempting to bring a tax case without actually making a tax law claim. Instead, the AG is proceeding solely under the New York False Claims Act in an effort to do an end run around.
I know that that's the same argument that amicus makes, that you really need a tax law violation in addition to an act violation. Is there a requirement that that be the case?
Well, Your Honor, the AG absolutely can bring a New York False Claims Act case based on a tax law violation. That's clear. The law was amended in 2010. But the statute that they have brought this case under requires that they show that Sotheby's had an obligation to pay sales tax to the state. They have to show that Sotheby's made a false statement or create a false record material to an obligation to pay money to the state. That obligation arises, if it does at all, we say it doesn't, under the tax law. There is no obligation to pay money to the state unless Sotheby's had an obligation under the tax law.
So the actual knowledge requirement that you and amicus claims is being watered down is part of the tax law, not the...
That's exactly right, Your Honor. And that's what we argue the AG has exploited in this case, essentially, because the False Claims Act requires that the defendant acts knowingly, but defines knowingly in a way that includes recklessness and willful blindness, not simply actual knowledge.
Why should we address that argument in this case where there's no question that they are moving on a knowledge basis, not on a reckless basis? They're clearly alleging that Sotheby's had knowledge. So to the extent it sounds like you're making a public policy argument that you shouldn't be able to bypass the tax law, why should we bite on that argument in this particular case, which is an actual knowledge case?
Well, Your Honor, our view is this is not an actual knowledge case. It has not been sufficiently pled. If you look at the complaint, and I'll point Your Honors to Record 13, Record 24, Record 47, they allege that Sotheby's recklessly disregarded its obligation to collect sales tax. They allege that Sotheby's employees recklessly disregarded the company's obligation. They used the language of recklessness throughout the complaint. That is not actual knowledge.
But they also talk about knowingly submitting false tax records to the state, right?
Well, the only, and again, we're under a fraud case, so we're under 3016 here. It has to be pled with specificity. The only place where they say this in the complaint, they say at Record 13 that through at least one of its employees, Sotheby's acted with actual knowledge. That one employee, as pled, is referred to as the KCM, the Key Client Manager. As pledged, she was a junior employee, 3 years out of college. Okay, they allege she wasn't adequately trained. And the allegation, and this is at Record 25, is that this employee mistakenly told the client that he could use a resale certificate because he might resell the work at some time in the future. Okay, now that may have been foolish.
Though, in this record, there's a subsequent salesperson or point of contact person who does the same exact thing, and the whole structure of Sotheby's is set up so that that point of contact person is the only one who gets to have the knowledge. Accountant is kept in the dark about it. There's many allegations that support that there was actual knowledge here, that Sotheby's was actively involved in this plan to evade intentionally paying sales tax.
Well, we respectfully disagree with that. I think if you look at the complaint closely, you'll see, and actually the Supreme Court below, as part of a basis for its decision denying our motion, said that Sotheby's was willfully blind in the way it set up its systems, which I think is what Your Honor is referring to. Willful blindness is not actual knowledge. That is not actual knowledge. And the actual knowledge standard is really the highest standard of scienter that you can have, and there's a reason for that. And there's a reason why for 60 years under the tax law, the requirement to collect sales tax when you get a resale certificate.
Well, whether or not you think it's sufficient, the complaint does allege actual knowledge in this case. It alleges that Sotheby's, through its 2 employees and the way it set up its system, had actual knowledge that these resale certificates were false.
Well, Your Honor, it says the words actual knowledge. It does say the words actual knowledge, but again, if you look at record 25, where it talks about the key client manager who's at the center of this complaint, she mistakenly believed that he could use a resale certificate if at some time in the future he might resell the artwork. That may be foolish, negligent, reckless. It's not actual knowledge. I just want to make one more point about
But doesn't that happen? I mean, this is a 3211A7 motion, right? So this, I assume that EBTs have not taken place. We don't know what each of the individuals involved knew at what time and in what place.
That's true, Your Honor, but it still has to be pled with specificity under 3016, and we don't think they're there in that
True.
standard. If I may, just for a minute, talk about another very important point that we make in our brief, which is the application of New York's complicity rule and the failure to plead vicarious liability here. The damages that the AG is seeking are unquestionably punitive. They have already recovered and been compensated for the taxes here. They settled with the customer years ago, and they are now seeking treble damages against Sotheby's for taxes that have already been paid.
Counsel, but you're talking about the purchase of 35 pieces of artwork on which, and furniture on which no taxes were paid, thanks to Sotheby's, totaling over $27 million. We're not talking about one errant event or 2 wayward events or 3 mistakes. This is big. It's a lot of volume, and it's a lot of money, and ergo, it is a lot of tax money that wasn't rendered to the state, et cetera.
Your Honor, respectfully, that doesn't excuse the Attorney General from the requirement to adequately plead vicarious liability here. And we are operating, we argue, under the complicity rule, because the damage is being sought. Again, the AG has been repaid the tax. They've settled with the customer.
Yeah, but that's not their main concern, right? So they even with respect to the tax that was not paid. But what about the scheme?
Yes, yes,
Are
yes.
they concerned about?
Yes, Your Honor, that's my point. The point of this suit is to deter and to punish. They're punitive damages. So under the complicity rule, they must plead that a superior officer of Sotheby's was involved in the wrongdoing. They have not pled that, and I don't think the AG will tell you that they have. They don't even argue.
But they can always move to amend that once some discovery takes place, right?
Well,
If they find out as part of a deposition that, in fact, the higher-ups are involved in this scheme.
I suppose they could try to do whatever they want, but we're talking about this
They can
complaint.
even amend to assert a tax law violation.
I think what would be appropriate is to dismiss the complaint, and then if the judge wants below, grant leave to amend. But this complaint cannot survive.
Yeah, but that'll just, that'll just mean you coming back here for the 10 more times, right? But let's hear from the Attorney General and
Thank
see
you, Your
what
Honor.
they want to do.
May it please the court, Esther Merdukayeva for the Attorney General. This court should...
Why wasn't there a claim for violation of the tax law put in the complaint?
Well, Your Honor, ordinarily the Attorney General does not have freestanding authority.
I'm having trouble hearing you.
Ordinarily, the Attorney General does not have freestanding authority to enforce the tax law. Violations of the tax law are typically enforced by the Department of Taxation and Finance. The Attorney General enforces the False Claims Act, and the False Claims Act plainly allows for the Attorney General to seek relief, whereas here false records are used and are material to an obligation to pay taxes. Now, what Sotheby's tries to do is manufacture a legal issue out of what is essentially a factual dispute by pointing to differences between the scienter standard in the FCA and in the tax law, but that really doesn't matter because the complaint pleads a violation even under the tax law standard that Sotheby's...
So you're not relieved of your obligation to plead or to prove actual knowledge. I mean, they're concerned, and frankly, the U.S. Chamber of Commerce concern is that you are watering down that actual knowledge requirement governing, vendors' sale tax obligations.
Your Honor, our position is that that question is simply not ripe before this court. This is on a 3211 motion. So the question is, have we stated a claim? And we have stated a claim even under the standard that Sotheby's claims applies.
What's your response to that it was only the one employee and maybe two employees who knew about what was going on, and that there's no allegation of any knowledge of any senior officials at Sotheby's as to what was occurring?
Well, I have a couple of responses to that, Your Honor. My first response is that the complaint does plead a direct liability theory based on certain corporate level decisions that Sotheby's made about how to structure the client accounting department and the sales department. But the complaint also pleads vicarious liability, and the complicity rule that Sotheby's relies on has absolutely nothing to do with vicarious liability under the False Claims Act. Vicarious liability under the False Claims Act is the same standard for vicarious liability as in all other forms of New York law. It is satisfied when an employee commits a wrongful act within the scope of their employment for the benefit of the employer or with apparent authority. That is a standard that this court applies all the time in agency and vicarious liability cases. This complicity rule comes up for punitive damages in tort, which are a form of exemplary, unique damages that require an extremely high level of culpability. What the FCA authorizes is treble damages. Those are statutory damages. Those are damages that are authorized by the statute. They're not exemplary. Some courts have looked to treble damages to determine whether a statute is constitutionally punitive for purposes of retroactivity or preemption. That has nothing to do with punitive damages. Punitive damages are a term of art in the tort context that simply don't apply here. This is a category error by Sotheby's misunderstanding case law using the term punitive in completely different.
So you don't think treble damages are a form of punitive damages?
Treble damages are not a form of punitive damages as that term is applied in the context of tort law, which is what the term of art references in those complicity rule cases. And I would just like to note that Sotheby's characterizes its participation in this conduct as being passive, that they just received these resale certificates and had no way of knowing whether they were false or not. That is not what the complaint alleges. The complaint alleges that the KCM introduced this idea of using these resale certificates to the collector, sent partially completed forms to the collector, filled in one of those forms with false information, and continued to facilitate this conduct over years. Now, what Sotheby's has argued is that the only thing the complaint alleges is that the KCM was mistaken about the scope of the law. That's not what the complaint alleges, and that is not the relevant question. The relevant question is whether the KCM knew that statements in the resale certificates were false. These resale certificates contain the statement that the collector or Porcel Equities were fine art dealers in the business of selling fine arts. The KCM absolutely knew that that statement was false. It has nothing to do with her understanding of what the scope of the law is. And I'd like to make a couple more points, if I may. Even the tax law standard permits finding of a lack of good faith based on the lack of reasonable due care and a lack of internal controls. That's what example 1 to the regulation provides. And here there are plenty of examples of a lack of adequate controls here based on the way that Sotheby's has structured its departments. You also have evidence, and the complaint talks about this, that the controls that existed, such as the requirement that purchases be made from a corporate bank account rather than a personal bank account, were overridden at the request of the KCM. At a minimum, that allegation shows that there is a lack of adequate internal control.
And the KCM, just to try to tie it all, you say knew that the collector was a foreign shipping executive, not an art dealer.
Correct. And she knew that from months before the first resale certificate was submitted and completed. And in fact, we allege that the KCM was the one who initially wrote in that false statement on the first resale certificate that was used. And one final note.
You agree that the KCM is not a high-level Sotheby's executive, right?
I agree, but I think that fact is irrelevant because she was acting within the scope of her authority and for the employer's benefit, and I don't think Sotheby's disputes that fact. The last thing that I would note is that it is undisputed that the collector and Porcel Equities had an obligation to pay sales tax on these items. And what the False Claims Act refers to is an obligation, which the governing regulation provides can be the obligation of the person making the false statement or some other person to whom to whose obligation that false statement is material. These resale certificates, the false invoices, and the false sales tax returns were plainly material to the collector and Porcel Equities' own separate obligation to pay taxes on these purchases, which again is undisputed. Thank you, Your Honors.
Thank you. Okay, you get a couple of minutes.
Your Honor, quickly, I heard the AG say, I think that the AG did not have the authority to bring a tax claim when Your Honor asked why they had not brought it here. And I believe they do. In fact, one of the cases cited in our brief, the B&H photo case, just last year, the Supreme Court dismissed the case after where they brought both a tax claim and a False Claims Act claim. The court found that they had not made out a claim under the tax law, and therefore there was no obligation to pay money to the state, and therefore dismissed the False Claims Act claim.
A separate question about the vicarious liability. What's wrong with the argument of the AG that this is a vicarious scope of employment case like any other case, as long as they can show that the two employees were acting within the scope of the employment and the furtherance of Sotheby's business in their activities, that's sufficient to impose liability on Sotheby's?
The key, Your Honor, is that the damages here are punitive damages, essentially. The way they have been
per se, because it's treble damages in the statute, that per se makes it punitive?
Not simply because of that, but in this case in particular, the AG has been compensated. They are not compensatory damages.
What's your authority? You're using the word punitive, which is a big word. What's your authority? Because punitive damages are typically unlimited. They can be millions of dollars, even if the claim is $1. What's your argument that these are punitive damages as opposed to just statutory treble damages, which are sometimes allowed for under the law?
The court,
violations.
Your Honor, in 2012, the Court of Appeals in the DHL case cited in our brief said that treble damages under the FCA are essentially punitive. In the Regina Metropolitan...
Punitive is different than punitive damages. That they have a punitive effect does not mean that they're punitive damages.
Well, I mean...
there is a whole body of case law about punitive damages separate apart from any statutory trebling of damages.
I think some of it's semantics, but if you look at the way punitive damages have been defined, even by Lowry in the case that talks about the complicity rule, Court of Appeals case, it talks about punitive damages. The purpose of them is to punish and deter. And the cases we've cited, the DHL case, the Regina Metropolitan case, a case of the Court of Appeals last year, the Stevens case in the U.S. Supreme Court.
We accept your argument, though, then Sotheby's gets away with it to the extent they did something wrong because the taxpayer is liable, the taxpayer pays, and Sotheby's doesn't have to incur any responsibility or liability even if they clearly did something wrong. If we accept what you're saying.
Well, no, they can be held liable. You just have to allege that a superior officer was involved in the wrongdoing. And the point of that rule, as the Court of Appeals has said, is that you're not punishing the entire organization and its shareholders for conduct unless top management is involved. And that's the rule. I mean, it's been the rule for decades in New York. Thank you, Your Honor. Appreciate it.
Thank you. Jeremias versus Tom's Capital.
Good afternoon, Your Honors. May it please the Court. Tibor Naj of Donson Naj here for appellants. The parties briefed 7 causes of action and multiple issues. I'd like to spend my time today focusing on 1 cause of action, plaintiff's breach of contract claim, and 2 issues related to that claim. First, I'd like to address the trial court's erroneous decision to allow the plaintiff here, a professional real estate developer, to pursue a claim of liquidated damages for $20 million, notwithstanding that his actual damages are less than $1 million.
Counsel, why are they liquidated damages? Liquidated damages usually means if you breach, then we're going to impose this set of damages. But that's not exactly how this clause works. It's not if you breach, we're going to impose this set of damages. It's that you have a choice. If you want underdevelopment to occur, you have to pay for that right. So it's not really a breach or liquidated damages under that construction.
Your Honor, it's because it is indeed a breach. The agreement here.
How is it, I'm going to let you finish, but how is it a breach if the agreement expressly provides for that eventuality? We understand that this is your whole motivation for getting involved in this deal, is that you want underdevelopment to occur, and that's fine with us. We don't have a problem with that. You just have to pay for that right.
Because, Your Honor, when you look at what the agreement here was, the plaintiff had no right. The plaintiff didn't own the property. He had no right to tell Mr. Gottesman what to do or not.
He was the developer, right?
Correct,
He was
Your Honor.
acknowledged to be the developer.
Yes.
The question was whether the entity that was formed was set up in order to develop a property, right? And although the 100% equity partner had no interest in developing his neighboring property, he had an option for which he would reimburse the development company for the space that's not utilized, as my colleague said, right?
No, Your Honor, that's not right. And part of the problem with this case is we have sophisticated parties with lawyers, many drafts of an agreement, but the agreement that is being relied upon is just an oral agreement, and it keeps changing throughout this case. Let me read to you.
Well, isn't that because a one-pager doesn't include all of the complete terms?
Oh, no, Your Honor, I say that because the claim, the oral agreement here keeps changing repeatedly. Let me read to Your Honors what I think is at the heart of this case. It's paragraph 8 of the verified complaint. Gottesman promised Jeremias that Gottesman would develop the property to its full potential or would pay liquidated damages to Jeremias for each square foot of space that went underdeveloped. Now, that was the claim until they read our summary judgment briefs and they saw how strictly construed liquidated damages claims are. Then they tossed that theory. And so when you actually look at the contract damages claimed here, what are they? It's $28 million total. And they lay it out in their interrogatory response. What did they do? It's a contract claim. What did they do to earn that money? They didn't sell the property. They didn't commit a dollar towards the property.
They gave up the right to buy the property.
Yeah, no, Your Honor. Actually, they did not. The existing tenant had a right to buy the property. He had a ROFO. We paid $76 million for this property.
At the time you agreed to pay, or your client agreed to pay the undevelopment fee, they did have a right to purchase the property, and the agreement on the drop-dead date was that they would give up the right and you would be able to pursue the right, and that certain things would be given in exchange. But let me go, let's assume your argument is correct. Assume arguendo that it is a liquidated damages. What's unreasonable about that amount? What evidence did you put in to show that that amount is unreasonable in any way in terms of the value of the square footage?
It's unreasonable, Your Honor, for several reasons. Primarily because it's punitive and it's not proportional to the actual losses. If you look at the actual losses that are claimed here by the plaintiff, it's less than $1 million. He doesn't spend any money of his own towards the purchase price. He doesn't do any work, and he lays this out in detail in his interrogatory response. It's at record 3203. It's where we ask him, what are your contract damages? How do you get $28 million? He doesn't do any work for this money. He's supposed to do development. We ask him, this is in the record, to make a proposal to do development. This is at record 1374, and he refuses to make a proposal. He doesn't want to do it. And so by not doing the work, how does he get to $28 million? It's purely by virtue of this liquidated damages provision, this formula that says if you don't develop the property, you've got to pay me. Now, why does he get to compel us to develop the property? He can't. We own it.
Because that's what you wanted, right? It was undesirable for your client to develop that next door property. Isn't the very reason why you agreed to pay another developing fee?
No, Your Honor, and that's a key point. And this actually, I believe, is determined by this court's decision in Silber. This whole thing about this underdevelopment fee, right? It's a very concrete formula, and the way you get to it is it's over $4,000 per square foot. My client didn't agree, and he, in fact, was sent a draft with this formula saying, if you don't develop your own property, you have to pay $20 million. And the one thing that's clearly not in dispute in this case is my client did not sign that contract.
Well, this is a summary judgment motion. We don't know, as you said, exactly what the agreement is. There's many different arguments floating around about what the agreement is or is not. And there's no way it could be determined on this record what is or is not the agreement. So by denying the breach of contract, it's just saying one of the claims being made is that your client did agree to pay and will go forward, will have discovery, and a determination will be made as to what the agreement was.
Two points on that, Your Honor. And respectfully, Silber, S-I-L-B-E-R, controls here. On summary judgment, where, as here, there's an alleged oral promise and the parties keep negotiating, there is no enforceable agreement. And that's what happened. Mr. Gottesman did not sign the document. He actually responded to it and said, I don't agree to this. With that record, you can't just say, send it to the jury. Maybe there is an agreement. It doesn't work that way. There was an alleged oral agreement after which the plaintiff concedes there was heavy negotiation. That's Mr. Skillman's own words to the trial court. He said they continued to negotiate dramatically and heavily. Negotiating is not an agreement. If you keep negotiating, there was no meeting of the minds. Second, Your Honor, the trial court did not—
There clearly was an agreement because you had a term sheet, and the question is what terms can get added onto that term sheet that will orally agree to in addition to the term sheet.
That is also a question of law, Your Honor, and that term sheet, we would agree, controls. In fact, we submit it does control. His client testified it was binding. He's now going to claim it's not binding. It's another change. The reason it's a legal issue is that term sheet says it contains the principal terms. You cannot construe this agreement to say a $20 million liquidated damages provision is not a principal term. And similarly, under Silber, once again, it's a decision written by Justice Gonzalez, not Your Honor, this is Justice Luis Gonzalez. In Silber, this court specifically said where you have an alleged oral agreement and then there are writings that show continued negotiations, which is absolutely the case here, you cannot hold that oral agreement to be enforceable. Mr. Gottesman did not agree to this liquidated damages provision, and to send it to the jury would be error.
Okay. Thank you, counsel.
Thank you, Your Honor.
May it please the court, I am David Skillman on behalf of the plaintiff. There is a factual dispute in this case as to whether the parties agreed to an underdevelopment fee. Now, plaintiff has presented evidence in the form of an affidavit from Mr. Jeremias and emails from Mr. Gottesman and his real estate advisor, Brack Capital, that there was an agreement on an underdevelopment fee.
What's your response to his argument that if it wasn't in the term sheet that there can't be an underdevelopment fee?
Okay, so the term sheet was not a final agreement, let alone an agreement on all the terms here. And to understand that, this court needs to realize the context in which the one-page memo was delivered to Mr. Jeremias. At the time it's sent, Mr. Jeremias, at the urging of Mr. Gottesman, has already kicked out his other investors from the deal. He's already executed an assignment of a $71 million purchase agreement. He's already, the go-hard deadline for him to get a refund on his purchase deposit has already expired. And there's no time to finalize a 30-page joint venture agreement. He's doing this all on a handshake, all in good faith that Mr. Gottesman is going to not renege on his oral promises. So he needs some kind of assurance. And Mr. Gottesman is willing to do that for him. He says, I want to let you sleep at night. I know it's not all, we don't have time to finalize this agreement, but to help you sleep at night, I'm going to give you a document, a few bullet points. It's not going to contain everything, but it'll help you sleep at night. So it wasn't a contract. I mean, it was evidence of a contract. It was evidence of what a prior oral understanding was. The document doesn't say it's a contract. Mr. Gottesman doesn't propose that Mr. Jeremias accept or sign it. There's no signature line for him to sign it. It's just a one-way memo memorializing some of their deal terms. When somebody memorializes or attempts to memorialize part of an oral agreement after the fact, that memo doesn't supplant the prior oral agreement. It doesn't become a contract. If I invite my handyman over and I say, I'd like you to paint a shed for $500. I'd like it to be this color. I'd like it to be painted on this date. I'd like proof of insurance. I'd like indemnity for any damages that happen. And you shake on it. If he comes back the next day and texts me and says, okay, shed painting, $500, that text is not a contract. That doesn't supplant our prior oral agreement. And this was the holding in Singer v. Zipto, cited in our brief. An unsigned memo. In that case, there were 2 unsigned memoranda. They didn't have merger clauses. They didn't have an integration clause. And one of the parties said, wait, this isn't the whole agreement. There was a prior oral understanding that had other terms. And the court said, yes, you can look to evidence of what that prior oral agreement was. Finally, even if this were a contract, it can't possibly contain all of the terms of the parties' agreement. How do we know that? Well, we just look at the defendant's conduct. Why does Tom's reimburse Mr. Jeremias for nearly all of his expenditures on this project prior to the go-hard date? There's nothing about reimbursement in the one-page memo. Why do they let Mr. Jeremias call Mr. Gottesman a partner over and over again without objecting? Why do they keep reassuring him that a partnership agreement is coming? There's nothing about a partnership in that one-page memo. Why in 2017 do they send a draft joint venture agreement to Mr. Jeremias, which they call a JV agreement, making Mr. Jeremias a member in a joint venture LLC? There is nothing about a JV agreement in this one-page memo. Why do they let Mr. Jeremias serve as the property manager and developer for 4 months after the go-hard date? The one-page memo says they're going to negotiate a development agreement. It doesn't say he's currently acting as the developer. So all of this is evidence that there was more to the agreement than what is in that one-page memo drafted by Mr. Gottesman's advisor. So there is a fact dispute in this case about the underdevelopment fee, and the defendants want to turn that fact dispute into a legal dispute. They say the underdevelopment fee is an agreement on, or is an oral agreement on liquidated damages. And our response to that is, so what? There's no rule that says an agreement on liquidated damages has to be in writing. If there were, it'd be in the statute of frauds.
Well, I thought your argument was that it really wasn't, even though you used the term liquidated damages, and we understand what that term, legal term means, but it's really an option. As my learned colleague pointed out, that if you choose not to develop and you have undeveloped square footage here, we agree to exercise the option to pay you a certain value for the undeveloped square footage, correct?
That is our argument.
And it is my understanding that that consistent theory that you've advanced and the number that you floated for square footage, I think it was approximately
20,000.
4,100, something like that, was a number that everyone agreed was the reasonable appraised value of the undeveloped square footage, correct?
That's correct. And if we want to quote our complaint a little more, let's move beyond the preliminary statement and look at the body, or look at the section of the complaint that talks about our causes of action. And in paragraph 122 of our cause of action section for breach of contract, we acknowledge that Mr. Gottesman had negotiated the right to limit development, limit the bulk, the vertical expansion of the building. But if he wanted to do that, if he wanted to exercise that option, he had to pay the price. So in paragraph 122, the plaintiff says, Tom's Capital breached this agreement by refusing to pay Harch for the square footage of space that was not used when the property was underdeveloped. So again, we're not saying that, or the plaintiff rather, is not saying that Mr. Gottesman breached by not developing. The breach happened when, upon exercising his option to limit vertical expansion, to limit bulk, he did not pay the agreed upon rate, the underdevelopment fee.
Well, I thought that was, at least based on his email, that he was concerned. In fact, he wanted to push back on the agreement about what the underlying underdeveloped space was, which at that time had been, I think you had said 20,540 square feet. He wanted to push back on that because he didn't know, what was going to actually be approved by the landmark.
Right, that email from Mr. Gottesman to his advisor, Brack Capital, in response to Mr. Jeremias' attorney's proposed revisions. Now remember, Mr. Jeremias' attorney sends those revisions jointly, directly to both parties without reviewing with Mr. Jeremias. Mr. Gottesman says in response, wait a second here. He's assuming Landmark's already approved 20,000 some odd square feet. That wasn't my arrangement with Mr. Jeremias. The arrangement was we see what we can get from Landmarks, then we subtract from that whatever I don't want or whatever I do develop, and multiply that by the agreed upon rate. The fact that Mr. Gottesman responds this way is actually proof that he agreed to the underdevelopment fee. If you didn't agree to any kind of underdevelopment fee, that's not your response. You say, I don't know what he's talking about. I never agreed to anything like this. Instead, he pushes back on the starting point that Mr. Oved proposes for the underdevelopment fee.
Thank you, Counsel.
Thank you, Your Honor. Briefly, critical point here on liquidated damages is if this is not a liquidated damages provision, then there is no such thing. You could simply say it's an option to breach. Well, that's not the case here. The complaint says very clearly Gottesman would develop the
Well, an option not to do something is not an option to breach, right?
Yeah, if, Your Honor, if I have to pay you because I don't do something that you claim I'm required to do, that is a liquidated damages provision.
Well, but if your underlying work is to develop because you're a developer, and I create an option to pay you if I don't want certain space to be developed, that's not a liquidated damages clause. There's no breach of.
You have to look at the consideration here, Your Honor. What was given to my client? Okay, what the plaintiff here claims is
No development is what was given to your client, which is what he wanted, because he didn't want the property next to him to be too developed, right?
what the parties here originally wanted to do, Your Honor, was they were going to co-invest. On the last day, Mr. Jeremias, who's represented by counsel, okay, he decides he's not going to invest. That's his choice. He doesn't plead duress. He chooses not to. So he doesn't put in any money. The parties in the term sheet agree that per the term sheet, they would try to negotiate a development agreement. What the term sheet doesn't say is, if you don't do that, you have to pay me $20 million. And to your point, Justice Kern, what's the evidence of the disproportionality here? It's wildly disproportionate. The record contains evidence that the value of a ROFO, if that's what he was giving us, was he gave up the right to buy the property. It's $5 million. That's what that was worth, not 20.
To develop it to its full capacity.
But he had no pre-existing right to develop the property. He didn't own it. He didn't have some right to develop it. This is all going to what was the agreement. And the agreement, Your Honor, on the point Justice Shulman raised, and you yourself, Justice Acosta, when you look at what the parties said, there's no way to construe this response from Mr. Gottesman as assent to liquidated damages. Quote, I was very upset to receive this. I can only hope and assume that this is the work of an overzealous lawyer. In any case on this basis, I will regrettably not move forward. We cannot send to a jury that and say, that's an agreement, that's assent. As a matter of law, it is the opposite of assent, no matter how wealthy Mr. Gottesman is.
Okay. Thank you, Counsel.
Thank you.
So I'd like to briefly address our cross-appeal, the arguments in our cross-appeal here. So specifically, our implied covenant claim, plaintiff's implied covenant claim. The trial court said that plaintiff's implied covenant claim was duplicative of its contract claim. Now, part of our contract claim said that Mr. Gottesman breached his obligation to pay Mr. Jeremias a 35% promote above a 12% hurdle. And he did that by improperly reporting the income and expenses on the project. But it wasn't just that he didn't properly report the income and expenses, it's that he found ways to pay himself or derive benefits for himself, and that he did so in a way that prevented or that resulted in the 12% hurdle never being hit. So what are the things that he did? Well, he negotiated a restrictive covenant on the property to prevent any future development that runs with the land for any future owner so that it creates sight lines into his private courtyard in his West Village compound. He negotiates an easement for an underground swimming pool into the property. He values that easement at $7 million with the buyer. But when it comes time to credit the project, the profits and losses, with profits and losses, he says it's only worth $3 million. He also doesn't credit the project for any of the value of the restrictive covenants that he obtains. Then he just invents a guarantee fee and pays himself $2 million for that. Now, none of that was a breach of an express contractual promise. He never promised not to pay himself $2 million as a guarantee fee, but at the very least, these bad acts violated an implied promise.
So essentially, he breached his fiduciary duties to his joint venture partner.
It doesn't even have to be a fiduciary duty obligation. He found a way to pay himself and avoid making a profit distribution to Mr. Jeremias. And that has to be an implied promise in any situation where someone is in control of distributing profits, so that there's an implied promise, I'm not just going to pay myself an unlimited amount of money to avoid making profit distributions to other people who have a stake in the project.
Thank you.
Thank you.
Thank you both. People versus Watson. Give me 1 second, Counsel.
Oh, sure. I'm getting timer.
Go ahead.
Thank you, Your Honor. Good afternoon, and may it please the court. Taylor Poore with the Office of the Appellate Defender on behalf of Lloyd Watson. Mr. Watson was charged with 2 counts of criminal sexual act in the 2nd degree, but the evidence at his trial described 4 separate acts of oral sexual contact that fit the charges, and the jury was never told by either the court or the prosecutor which of those acts they should consider for the charged counts. The prosecutor referenced all 4 allegations in her summation without clarifying which of the 2 of them corresponded to the charges, and that was the last thing the jurors heard before they were instructed by the judge, who told them that the verdict must be unanimous, but did not tell the jurors that the verdict must be unanimous with regard to each act.
Was this issue preserved?
It is absolutely true that the trial lawyer did not adequately preserve this issue at the time that it would have been appropriate to do so. But so we are asking this court to reach the issue in the interest of justice, and that is appropriate in this case for a variety of reasons. First and foremost, because here the court and the prosecutor were on notice from the outset of the case that duplicity was a risk here, and that the evidence, the only thing that had saved the grand jury evidence from duplicity was that the jurors were properly instructed, which did not happen at trial. And I think in this case, what's important to recognize is that there is every chance that Mr. Watson was found guilty because of, for count 1.
You don't think that the arguments that were made by the prosecutor during summation, focusing solely on the Yankee Stadium incident and the uniform exchange incidents, you don't think that there's very little chance that the jurors will have relied on other incidents, the other 2 or 3 incidents, in order to convict?
Here, actually, the prosecutor talked about all 4 of the acts in her summation. She talked about the All-Star Game incident, and she talked about the mouth-to-anus contact that was mentioned in the Facebook messages, and she did not at any point clarify which of those 4 related to the charges.
There was argument that the mouth-to-anus conduct was to show consciousness of guilt.
That was not the consciousness of guilt evidence. That was referred to, there was obviously extensive Facebook evidence here, Judge. Okay. And so I would just say that in this case, there is every chance that Mr. Watson was in fact found guilty based on the All-Star Game allegation, because that was the only allegation that he actually assigned to a specific date that did not change. And then there's also every chance that some of the jurors found Mr. Watson guilty
of the mouse to anus allegation because that was the only one that was referenced in the Facebook messages. So for those reasons, those allegations actually had slightly more detail than the very, very limited detail that was available for the charged counts. And in this case, there's really no reason that this court can look at this record and say with confidence that Mr. Watson was actually convicted by a unanimous jury on either of the top two most serious charges against him. Just to briefly move on to the excessive sentence argument. Your Honor, Mr. Watson's sentence here after trial was more than 3 times the length of the offer that the trial judge made him, even after she had looked at all the evidence that had come out at trial, as well as a significant amount of damaging evidence that she herself
So he got
excluded.
14 years,
Yes.
right? Followed by 10 years of post-release supervision.
Right,
He was originally offered 4 years.
correct,
And that was before trial.
correct.
So you argue he's basically was penalized 10 years.
It's a significant trial tax, and I have not been able to find any cases that approach that. Certainly, the respondent has not cited any cases that have upheld that kind of a leap. I think it was incredibly severe. And if the court decides not to reverse Mr. Watson's conviction, the court has options, including to make the sentences concurrent. Keep in mind that we're not requesting the minimum, but the minimum here was 2 years of concurrent time. So that is a huge distance from the 14 years, the legal maximum that Mr. Watson received.
Okay.
It's my understanding that there was some history before this crime that was considered by the court in sentencing. Am I correct?
You're absolutely correct.
In that he was engaged in grooming, or he was sentenced to probation for similar kinds of behaviors with young teenagers.
And that was all in front of the judge, and she referred to that even before she renewed the 4-year offer before trial. So you're correct, Your Honor, but that was also in front of the trial judge at the time she made the 4-year offer.
Thank you.
Thank you.
May it please the court, Charles Wan for the respondents. Your Honor, here the prosecutor's summation made it clear that the first count referred to the bathroom stall incident near the Yankee Stadium, and then the second incident referred to the incident that occurred in September in the rear stairwell of the complaining witness's apartment. And because the prosecutor's summation focused only on those 2 events during her summation, she did mention the All-Star event, but she just mentioned briefly, and she did not mention that any kind of a criminal or sexual act occurred on that date. And in regards to the Facebook messages, the prosecutor's comment was that the defendant sent those messages and told the complaining witness to delete it as a sign of consciousness of guilt. So here, the prosecutor's summation made it clear that the first incident referred to the Yankee Stadium, and then the second count referred to the one in the stairwell at the complaining witness's apartment. And in regards to the excessive sentence, the prosecutor made it clear that the 4-year offer was so the complaining witness would not have to testify about what had happened to him. And the court also made it clear that his sentence was not a punishment for going to trial, and made it clear that the reason for the sentence being greater was because the defendant was on probation for similar acts, and despite that, being told not to engage in any kind of activities with minors, within a couple of weeks of being put on probation, he formed his baseball team and conducted these immoral acts which we're discussing here. There are no questions. People request an affirmance.
Thank you.
Just briefly, Your Honors, regarding the summation here, it is absolutely true that the evidence that these messages were deleted was argued by the prosecutor as evidence of consciousness of guilt. But what in fact she said, I think it's very important to focus on what the prosecutor actually said in her summation, which chronologically ran through the complainant's testimony. The way she framed the case, she referenced all four of the acts, of the allegations, and she drew no distinction between them. So she talked about the Yankee Stadium allegation, she talked about the All-Star Game allegation, she talked about the back stairwell allegation, and she talked about the mouth to anus allegation from the Facebook messages. After she went through that list, she made it sound like any of those allegations could form the basis of the charged offenses, and that's especially because she specifically called the mouth to anus incident, allegation, criminal and nasty. And she also talked about how Mr. Watson sent people away from the living room in order to commit his crimes. And she explicitly reminded jurors to think about any event that happened in the summer of 2015 when they were determining his guilt. Again, that was the last thing that the jurors heard before they were instructed by the judge, who told them repeatedly that oral sexual conduct could mean mouth-to-penis conduct or mouth-to-anus conduct. There is nothing on this record that allows this court to be confident that Mr. Watson received a unanimous verdict, and that is exactly why interest of justice jurisdiction exists for situations like this.
Okay.
Thank you.
Thank you, counsel. How much time has he served already? So this was 17.
So he's been in since then, Your Honor, so at least,
Okay.
I think the trial was in late 2017, so.
Okay. Thank you.
Thank you.
People versus Lewis.
Good afternoon, Your Honors.
afternoon.
David Clem for Appellant Alexander Lewis. The video in this case shows that Mr. Lewis didn't make any contact with the employee of the cell phone store. The employee didn't testify. No eyewitness testified.
So his shoulder, because I thought the video show, you know, when Mr. Mercado went to get the backpack, the defendant used his elbow.
That's not what I see in the video. Mr. Mercado makes contact, whether he's grabbing him, pushing him, or shoving him is completely unclear in the video. Mr. Lewis spins around. He doesn't raise his arms in any way. He spins around and falls out the door. The question is that force that Mr. Lewis used to, in this case, retain the property? It's a very thin reed on which to base this conviction, and I submit it's not sufficient for that purpose.
In the absence of Mercado and Rosario testifying.
In the absence of some eyewitness testifying to something more than what we see on the video. What we see on the video is the entirety of the evidence of force here.
That's not accurate. You could also rely on circumstantial evidence. In other words, when the store owner got the call from the victim and came back and saw him trembling and his shirt torn and the dynamics of some kind of struggle, there are reasonable inferences that could be taken from what took place outside the store. You're arguing he was trying to escape as opposed to trying to retain the phone for purposes of satisfying the element of the robbery charge. That's your view, but the jury can look at the totality of that testimony
The jury
and the
is
surveillance video, which they saw, and said, yeah, it looks like robbery, read us.
Of course, the jury is welcome to look at that. The evidence, though, just to be clear, was that he was shivering and his shirt was either pulled down or ripped down. There was no further description there, whether that came from him running after our client or not, we don't know. We don't know what occurs outside of the video. So to call that the evidence that Mr. Lewis used force is a pretty big leap here that there's no evidence supporting why that inference should be drawn, particularly in a case where there is a no adverse inference charge properly given here, because the people fail to produce the necessary witness here. So it's not that all these inferences are just free to be drawn. And in this case, there's lots of explanations for why Mr. Rosato may have been shivering that don't involve Mr. Lewis having used force in the retention of the property. When Mr. Lewis spills outside the door and falls to the ground, there is no contact visible between the two after that point. The prosecution in summation makes up a tale about a struggle that is not visible in the evidence that your honors have seen. That cannot support the robbery charge in this case. There are just too many assumptions being made without the proper witnesses being brought forth, and with the grainy surveillance video just not showing that the robbery occurred.
Yeah.
Thank you.
Thank you, Mr. Clem.
May it please the court, Alexander Michaels on behalf of the people. The evidence at trial showed that defendant stole a phone from a store, that the store clerk tried to stop him, and that defendant then used force to overcome the store clerk's resistance. The use of force was most obvious from the fact that—
That's all reflected in the video?
It's not exclusively reflected in the video. It's also reflected in the testimony of the store owner, Rosario. And her testimony was that when she saw him minutes later, the store clerk that is, he looked like he had just been in a fight and his shirt had been ripped down. He was also trembling and he was asking for water repeatedly. That testimony really reinforced the conclusion that we already have from the video, which is that, yes, there was some kind of struggle between the defendant and the store clerk as the defendant was trying to make off with the stolen merchandise. That struggle appeared to have happened twice, both inside the store and outside the store. First, there was some contact as they're in the doorway, as the store clerk is trying to keep him from leaving with the phone. And then outside, it's not clear what the precise movements were, but it's very clear that the store clerk was forced to retreat from defendant at some point. Whether it was because of a threatened use of force or actual direct application of force is unclear. But either way, the force requirement for robbery would be satisfied here. Unless the court has any questions?
Yeah, what happened to Mercado?
Mercado, they tried to track him down. There was an extensive record about this at trial. They tried to track him down. They had previously been in contact with him, but they were unable to track him down. Apparently, the cell phone was the main point of contact there, both for the store owner and for the people who were investigating this case. And his cell phone was disconnected, and he went to another job, and so they were unable to find him. And of course, there was an adverse inference charge that was delivered as to Mr. Mercado. And that was a permissive adverse inference charge. And the people did elicit testimony explaining how they tried to track him down through Ms. Rosario in particular. So the jury was, of course, very much able to consider the people's efforts there and whether that adverse inference actually should be drawn in this case.
Okay, thank you.
Thank you very much.
Just to touch on the one bit, my friend says that the video shows that the employee was, quote, forced to retreat. Again, I don't see that in the video. I know your honors have and will view the video, but what we see in the video is the employee reaching down and seemingly picking up something from the ground and then moving away. Again, none of this shows that Mr. Lewis used force in this case, and the robbery charge is just not supported. Thank you.
Thank you. Yeah, very good. Scott Wall?
Good afternoon, Your Honors. Anton Metlitsky for Ms. Siebert. First of all,
Thank you for allowing us to present argument in this case. May it please the court. I don't think there's any real question that Greg Clerick's notes are critical evidence in this case.
But the question is why they were not produced. I mean, it's not like Proskauer didn't have them. It's not like they didn't. I mean, you had the end of discovery on August 2018, the note of issue filed September 2018.
Right.
I mean, you folks, you know, live here in the appellate division. You've been here so many times. And somehow notes cannot be produced. Mr. Abrams' name cannot be named as a witness. What's going on here?
Your Honor, I mean, my colleague, Ms. Godesky, submitted an affidavit in the trial court that explains simply that we didn't know about these notes. There was no obligation, at least on our understanding.
But they were asked, counsel was asked, did these notes exist? And the answer was no, we only have a few cases in the file, et cetera.
No, Your Honor, and you can look at that exchange on 203 of the record. That was in a different litigation. That was a litigation brought by David Sonnenberg, Kesha's former manager, against Kesha and Dr. Luke jointly. It was a tortious interference case. And there was some discovery request, I don't know what it was, and there was a privilege log produced in response to that discovery request. There was a line item on there that said Manat file, and Sonnenberg's lawyer asked Kesha's lawyer at Proskauer, does whatever that Manat file is reflected on that privilege log, does that file contain handwritten notes or just cases? And he said, just cases, not handwritten notes. The question wasn't, is there some file at Manat with handwritten notes? And the answer to that being no. Right? Sonnenberg's lawyer never asked that question, whether there were any notes. Well, Your Honor,
I mean it's almost sophistry, you know. It's if I ask you, I mean, you know what they were after. They were after notes, rather than legal research.
No, Your Honor, I have no idea what they were after because this was a response to a particular discovery request. There's no reason to think that it was a discovery request about conversations between her lawyer, Kesha's lawyer at Manat, and the night in question. I don't know. They probably
the problem is that if they ask for notes about another file,
right,
you'll be here or back at the appellate division arguing that they're fishing and looking for privileged information.
Well, no, Your Honor. I mean,
you can't win.
No, to the contrary, Your Honor. So, I mean, their position in this case is that we were obligated to search every file to which Kesha had access, including all her lawyer's files, for documents, right? That's their position. That's why they say, okay, well, if that's true, then they should have had to search their lawyer's notes for any conversations that were responsive to our discovery request. Well, where is their privilege log reflecting all the conversations that Dr. Luke had with his lawyers about the night in question? There is no such privilege log because nobody thought that that was their discovery obligations. And Your Honor, to be clear, obviously it would have been better if we had learned about these notes and produced them before the discovery cutoff. But
Counsel, isn't it just too late now? Whether or not it was intentional or not intentional, isn't it just too late now?
I don't.
Discovery's been closed for years. This case is going to trial.
No, I don't.
Isn't it opening up a big can of worms? Because if we allow this, then we're going to allow a lot of other things.
Well, so Your Honor, I mean, I think 2 points. I think there are 2 questions embedded in there. First of all, we're a year from trial. If you look at the Beach case, this court's case from 2 years ago, the documents in that case were produced after they should have been produced, according to the trial court in that case, during trial. And this court still held, well, there's no reason to preclude them so long as there's a way to ameliorate the prejudice. And the way to ameliorate the prejudice in that case was give them a short continuance to review the documents. The way to ameliorate the prejudice in this case is give them a deposition of Mr. Clerick. If they want to depose him and ask him about the notes, that's fine, but they have a year to do it. They don't even argue that that's a problem. Their whole argument is that actually, because this was a waiver of attorney-client privilege, that the subject matter waiver doctrine means that now, not only do they have access to conversations between Kesha and Mr. Clerick as to the subject matter, but any conversation that Kesha has ever had with any lawyer in her life about the night in question, which is, of course, precluded by People Against Kozlowski, by U.S. Fidelity Guarantee Company, which is a decision from this court, which said that one party's waiver of the attorney-client, I'm quoting, attorney-client privilege was limited to communications between its officer and the in-house lawyer whose advice the officer had disclosed at his examination before trial. And because, as in this case, the party in that case was not relying on an advice of counsel defense, quote, our finding of waiver did not extend to the party's communications with any other attorneys concerning this subject matter.
Okay. All right, let me hear from the other side.
Thank you, Your Honor.
Good afternoon, Your Honors. My name is Jeff Movitt for respondents.
You were not specific enough with respect to the handwritten notes in some other file at Brascour.
Yes, I was counsel in that other earlier case, and that case was about the exact same allegations. Although at the time, Ms. Siebert said that, which we submit was truthful, that there was no sexual assault and there was no drugging. So any insinuation that the question that Ms. Siebert's agent answered that there were no handwritten files pertained to some other subject matter is completely untrue. The subject matter was one and the same in both cases. This is a clear example of a judge, Justice Schechter, properly exercising her broad discretion to enforce discovery deadlines. As Justice Schechter held, these demands were the subject of a, quote, proper demand, close quote. She rejected the the defendant's argument that somehow there was no obligation to look for relevant hard copy documents, and that the defendant was trying to confuse ESI custodians with the obligation to find relevant hard copy documents. That was flatly rejected by the trial court.
This is scheduled for trial?
Yes, in February, Your Honor. Okay. With respect to it's also undisputed from counsel's affirmation that these documents are always in counsel's possession, custody, and control, and thus the client's possession, custody, and control. And all it took to get them was a phone call. That phone call could have been made at any time during the discovery period. It was not. There was a choice, as the affidavit makes clear, to wait to make that call until 2 years after discovery ended. Moreover, with respect to preclusion, the law of this department is very clear that there's 2 categories of preclusion orders. One is called the quote-unquote harshest orders, and those are for things like striking a pleading or preventing a party from making a defense. And then the other type of orders are things like precluding a document that wasn't timely produced or imposing a monetary sanction. And the First Department law is clear that the first category requires willful or contumacious conduct, and the second category, including precluding a document, does not. And while we do think that this was willful in that it was the subject of a proper demand, they could have asked for it at any time. Everyone knew Mr. Cleric was a witness. Everyone knew his documents were relevant. Documents from Mr. Cleric that are not privileged were produced timely. They still waited until 2 years or more after the close of discovery to not only produce a document, but try to waive a privilege that was adamantly maintained throughout the course of the case. As Judge Schechter also recognized, there were objections to questions about communications with counsel during the case. Contrary to counsel's representation, communications with counsel prior to the commencement of litigation absolutely were logged, so it's not correct to say they were not. As the judge said, and I'm going to quote the judge, had respondents timely known of the notes and the waiver, they could have altered their strategy and argued there was a much broader waiver of privilege. Respondents could have sought significant additional discovery. Discovery deadlines are intended to prevent exactly this, close quote. While the defendant would like to cabin a privilege waiver to the one attorney whose notes these were, that's not how it works. The cases talk about not using privilege as a sword and a shield, and that's the very nature of subject matter waiver. To be clear, would never argue that Ms. Siebert's privilege with Melvini, her current litigation counsel, was waived. However, she told a completely different story to her lawyers at Proskauer Rose in 2011 when she adamantly said there had been no assault and there had been no drugging. It would be completely improper for Ms. Siebert to waive the privilege as to the attorney communication she likes on the very subject of the events of this night from a 2005 lawyer, while trying to use a shield of a privilege to keep communications that would be harmful to her case about the very same subject out of the record. For all these reasons, this was a standard, appropriate, and very wise exercise of broad discretion for the judge to manage her docket.
Thank you, counsel.
Thank you, Your Honor. Just a few quick points. First of all, I think my opponent's contention is because the documents were late, it was within the court's discretion to preclude them. That is not
No,
true.
I think he's saying something different. I think that he thinks that his clients demanded the documents that related, to Keisha's prior attempt to repudiate the KMI agreement and his alleged provision of a date, rape, drug, and any sexual abuse.
Absolutely, and that's always true. That's true in every single one of these cases because the predicate to every one of these cases is that there was a discovery request and the documents were produced late. But you can't preclude for two reasons. First of all, we think the bad faith standard applies. It's not true that that doesn't apply to striking evidence. The Beach case was striking evidence. The Corrigan case was striking evidence. But even setting the bad faith standard applies. This is a quote from Beach quoting Merrill Lynch from the Court of Appeals. Although it is within the trial court's discretion to determine the nature and degree of the penalty, the sanction should be commensurate with the particular disobedience it's designed to punish and go no further than that. In Beach, this court held that even though the documents were produced during trial.
We're familiar with it.
All right.
Thank you, counsel.
Thank you, Your Honor.
You get 1 minute on your cross appeal.
Thank you, Your Honor. With respect to the Beach case, that case precluded, the lower court precluded the appellants from relying on SEC violations as a basis for fiduciary duty counterclaims. That is nothing like what's happened here. Here, Justice Schechter merely said the defendant may not use a document, which, by the way, the defendant wasn't even part of the conversation or allegedly reflected in that document. Judge Schechter is no way precluding, through this order, Ms. Siebert from claiming a sober pill or trying to introduce any other evidence of a sober pill. The only thing that this order does is preclude a document that, if disclosed, would create a tidal wave of new discovery and discovery fights and privilege fights, and to which Ms. Siebert was not even a party. The document was between a lawyer who she testified she'd never met and her manager. And the manager was purportedly repeating conversations he had heard from Ms. Siebert's mother or from Ms. Siebert herself. So these notes are many steps removed from anyone with personal knowledge. And again, no other alleged evidence is being precluded by this order. This is nothing like Beach.
Okay, thank you. Thank you both. Hopefully, we'll only see you after trial.